Arkansas called a massacre a riot for 100 years. What would the world be without black people? Well, there would be no reason for the United States Supreme Court to explain, in writing, that a courtroom surrounded by a mob is not a courtroom at all. It took a body count to force that sentence into existence. Nobody agrees on the exact number. Everybody agrees on how it started. September 30, 1919. A church at Hoop Spur, 3 miles outside Elaine, Arkansas. Black sharecroppers gathered there at night because daylight meetings got reported straight back to the landowners. Cotton prices were the highest they had been in years. The men picking it were still broke, kept that way by a bookkeeping system only the landlord ever got to check. Under the tenant farming system, landowners kept the books, set the prices, and settled accounts once a year in their own favor with no way for a sharecropper to check the math. Some of the men at that meeting had just come home from fighting for the United States Army in France. They came back from a world war unwilling to accept a rigged settle-up sheet as the price of being black in Phillips County. They had formed a union, the Progressive Farmers and Household Union of America, led by a man named Robert L. Hill. They hired a lawyer, Ulysses Bratton, to sue the plantation owners for an honest accounting of what their cotton had actually earned. That was the entire plan. Get paid. Get a lawyer, get receipts. If nobody taught you that, do not feel bad. That was on purpose. Subscribe and share Way Blackwen for more buried stories they tried to erase. Here is what asking for an honest accounting cost them. A church at Hoop Spur. Cars pulled up outside the church that night. Shots came out of the dark. When it ended, a white security guard for the Missouri Pacific Railroad named W.A. Adkins was dead, and a white deputy sheriff, Charlie Pratt, was wounded. To this day, nobody can prove who fired first. What happened next did not wait to find out. By morning, word had spread through Phillips County and across the river into Mississippi that black sharecroppers were planning an uprising to unalive every white family in the Delta. It was not true. It did not need to be. The rumor becomes an army. Close to 1,000 armed white men poured into Phillips County by the next day, some driving in from Mississippi. Local leaders wired Governor Charles Burr for help. Burr secured roughly 500 federal soldiers from Camp Pike. Some military orders list the number at 583 and rode the train down himself. The Arkansas Democrat reported the troops arrived under orders to shoot to kill any Negro who refused to surrender immediately. Some units did exactly that. Others, by their own soldiers' later accounts, turned machine guns on black families as they came out of hiding, thinking they had finally been rescued. Burr later called the response absolutely under control. He meant it as praise. 4 days in Phillips County. From September 30 to October 2, white posses and federal troops swept through the fields, the cane brakes, and the homes of Phillips County. Families were hunted while picking cotton. Men were pulled off trains nowhere near the church at Hoop Spur. Captured black residents were marched into a commandeered schoolhouse, turned stockade, and interrogated for any tie to the Union. One man, judged too insolent for a mob's taste, was doused in kerosene, set on fire, and shot. Homes were destroyed. Families scattered as far as Chicago and never came back. Every hater who rode with that mob went home free. Every survivor who ran out of the fields went straight to a cell. A group of white planters, businessmen, and elected officials formed what they called the Committee of Seven, supposedly to investigate the cause of the trouble. In practice, they decided who got arrested, whose testimony counted, and who would be blamed for it in the newspapers. Governor Burr met with them personally and accepted their version of events, in exchange for their promise that no lynchings would take place in nearby Helena, as if that promise covered what had already happened out in the fields. The secretary of a nearby black fraternal lodge later said he personally paid death benefits for 103 members. He said the lodge's own people knew of at least 73 more who had died in the violence and were never entered on any official list. Colonel Isaac Jenks, the officer commanding the federal troops, filed a report claiming his own men had killed exactly 2 black people. A Memphis press correspondent on the ground that same week wrote that many more had been killed by the soldiers themselves. Both accounts cannot be true. Only one of them was ever treated as the official record. 5 white men died during the violence, at least one by several accounts from friendly fire. Their 5 deaths were the only ones Arkansas ever formally investigated. 200, count uncertain. Nobody knows exactly how many black people were unalived in Phillips County that week, and that not knowing is not an accident. Modern historians, including the Equal Justice Initiative, put the number at 200 or more. The most conservative sourced range runs from 100 to 237 documented deaths, with credible modern estimates reaching well into the hundreds beyond that. A Southern journalist writing in 1925, no friend to black Arkansans, put the toll at over 800. State investigators took depositions, filed reports, and kept careful records on all 5 white deaths. No agency ever conducted an equivalent inquiry into how many black residents of Phillips County simply did not come home that week. A state that could name every one of its white casualties never built a list for its black ones. Charged with their own massacre, when the shooting stopped, 122 black men were indicted by a Phillips County grand jury. Not one white man was charged with anything. 12 were sentenced to death. 67 more were sent to prison. The trials for the 12 took less than an hour each, some closer to 45 minutes. The all-white juries heard no defense witnesses because the defense called none. Later sworn affidavits from white men who had been in the room described black witnesses being whipped and tortured until they gave the state the testimony it wanted. Men were sentenced to die in a courtroom a mob was standing outside of, on evidence beaten out of other black men. That was the entire case against them. Scipio Africanus Jones goes to Washington. NAACP Field Secretary Walter White, light-skinned enough to pass, traveled into Phillips County disguised as a white reporter and got the story out before he was identified and told to leave town or be unalived himself. Ida B. Wells published her own account the following year, titled it the Arkansas Race Riot, using the very word the state would hide behind for the next 100 years. A man named Scipio Africanus Jones took the case. He had been born into slavery near Tulip, Arkansas, in 1863, the son of an enslaved teenager named Jemima Jones. He taught himself law, became the first black attorney to build a real record of appearances before the Arkansas Supreme Court, and by 1919 was the most respected black lawyer in the state. He took on the Elaine 12 alongside white attorney George Murphy. The Arkansas Supreme Court rejected their first appeal in 1920. In 1921, 2 white witnesses came forward with sworn affidavits describing exactly how the testimony against the Elaine 12 had been extracted. NAACP President Moorfield Story argued the case before the United States Supreme Court on January 9, 1923. On February 19, 1923, the court ruled 6-2 in Moore v. Dempsey. Justice Oliver Wendell Holmes wrote for the majority that a trial conducted under mob domination is without due process of law and absolutely void. For the first time, federal courts could reach into a state's own criminal conviction and overturn it if the trial itself had been poisoned by a mob. Governor Thomas McRae commuted the last death sentences on November 3, 1923. The final men were not released from prison until January 13, 1925. 5 years, 3 months, and 13 days after they walked into a church to ask what their cotton was actually worth. What Elaine bought the rest of us, every American who has ever had a wrongful conviction reviewed by a federal court, because the trial itself was compromised by mob pressure or public hysteria, is standing on ground that 12 condemned sharecroppers and 1 self-taught black attorney had to force open with their own case. Moore v. Dempsey is the decision legal scholars point to when they explain why the federal system can step into a state court at all. It became the foundation later civil rights era rulings built on, part of what eventually widened into the sweeping federal habeas corpus protections defendants rely on today. 9 years later, the Supreme Court leaned on that same due process reasoning in Powell v. Alabama, the Scottsboro Boys case. Another set of black defendants railroaded through a courtroom under mob pressure. The line runs straight from a church in Hoop Spur to a legal doctrine still cited whenever a state trial gets accused of being a lynching with better paperwork. Nobody in that church on September 30, 1919 was trying to reform American constitutional law. 12 men just did not want to die for a shooting they did not start. 100 years of the word riot. For most of the 20th century, Arkansas history books, state records, and reference works called this the Elaine Race Riot. Even now, one of the standard reference sites for Black American history titles its own entry Elaine, Arkansas Riot, then spends nearly every paragraph underneath correcting itself. The word riot did specific work. It implied the sharecroppers started something. It let the state file its black dead under their own alleged crime. In 2019, ahead of the 100th anniversary, Arkansas lawmakers tried and failed to pass an official state apology. The same year, the United States House of Representatives passed a resolution honoring the victims and recognizing the legal legacy of Moore v. Dempsey. The federal government could say the word massacre before Arkansas's own state house could. On September 29, 2019, a privately funded memorial went up in Court Square Park in Helena, West Helena, 25 miles from Elaine itself, a location some Elaine residents felt stole the story from the ground it actually happened on. A 14,000-pound cenotaph carved with one line, dedicated to those known and unknown who lost their lives in the Elaine massacre. Known and unknown. 100 years later, and the state still could not commit to a number. So, what would the world be without black people? Well, there would be no Moore v. Dempsey. No ruling on the books saying a mob outside a courtroom voids everything that happens inside it. No legal doorway for a state prisoner of any color to argue in federal court that a conviction was extracted by terror instead of evidence. 12 sharecroppers who walked into a church to ask for an honest cotton count ended up rewriting how far the United States Constitution reaches into a state courthouse. They did it from death row. They did it with a lawyer who had been born enslaved 30 miles from where he later argued their innocence. They did it after white men killed as many as several hundred of their neighbors, and the state responded by charging the survivors with the crime. Their names are not on the Phillips County grand jury list that survived. Most of them are not written down anywhere. They are known and unknown, on a slab of concrete in a park 25 miles from where they died, because for 100 years, unknown was the only category Arkansas was willing to give them. Elaine, Arkansas, 1919. Hundreds of black sharecroppers dead, 12 men sentenced to die for surviving it.